So I get to talk to you about the new change to the Mass Equal Pay Act, which I'm sure everybody's here for. I don't think you care about anything else other than this, I'm sure. So basically, we did have a Mass Equal Pay Act. It has been revised. It's now more comprehensive. I'm going to give you a quick overview, and then I'll give you some of the detail. So it is effective July 1, 2018. So it's coming. There are some steps you can take to put yourself in a better position from an employer's standpoint. Under the statute, which we'll talk about in a second, it applies to all employers in Massachusetts. It even applies to employers who are outside Mass if they have employees whose primary place of work is in Massachusetts. So for some of you multi-state employers, you need to be cognizant of this act. It applies to virtually all employees. It would not apply to employees of a charitable association. So if you fit that definition, then your employees are not covered. So generally what the Act does is it prohibits discrimination on the basis of gender. The statute clarifies what is discriminatory pay practices and imposes some new rules. It defines what comparable work is. Prior to that, we had case law. This is much more detailed as to what it is. The prior Act only allowed seniority as a basis for varying compensation. This now gives you some other variations that you can use to differentiate on compensation, but they're very narrow, they're limited, and they're exclusive. And we're going to go over them in a second. You can no longer, under this Act, ask an employee about their pay history. It is unlawful to prohibit employees from discussing their wages or talking about others' wages unless you're in certain types of positions, which I'll get into in a minute. And it provides for an affirmative defense for employers. So there are steps you can take to get that affirmative defense. There has been some guidance issued by the Attorney General's office. They're not regulations, it's guidance. They tend to be given deference by the courts. And those are worth looking at, gives you more detail on the Act and some of the terms within the Act. So the basic prohibition in the Act. So let's get into a little bit of detail. So what it does is it prevents an employee from discriminating on the basis of gender for the payment of wages. And you can't pay any person that you have as an employee wages that are less than the rates you pay to other employees who do comparable work. Comparable work is a key term. It describes what it is, and we're going to go over that in a second. The other key word is wages. What are wages? Wages are any remuneration for employment. So we're talking salary, bonus, benefits, stock options, stock grants. All of that is part of the compensation. It all has to be done so it's equal. There's no differentiation on the basis of gender, so long as they're doing comparable work. What's comparable work? The current statute did not define it. As I mentioned, it was all case law. This new statute, which is effective again July 1, does define it. And what it does is it says that comparable work is work that requires substantially similar skill, effort, responsibility, and it's performed under similar working conditions. So let's just talk briefly about what each of those topics are. So let's start with skill. Skill is essentially, and this is in the guidance, experience, training, education, what's the ability required to perform the job, and it's measured in terms of performance requirements. And when you're looking at these factors, you got to look at the job as a whole. Effort is physical or mental exertion that's needed for the job. Responsibility include degree of discretion, degree of accountability, your duties, the actual duties, whether the number of people and who you supervise and the degree that you supervise individuals, as well as the degree to which you are supervised. And then what's your decision-making capacity. Performed under similar working conditions. So you can account for different working conditions like travel, shift differentials, physical surroundings. It's an outside job versus inside. Are there hazards? Am I working with chemicals that are dangerous? when I'm filling up packages or I'm just filling something that's non-dangerous. So those things you can look at. And then the job title or description alone is not enough. So you can't say, oh, I gave them a different job title, they don't have to be paid the same. Under this statute, you're going to look at the job as a whole. The job title's not going to matter, the job description's not going to matter. However, if you have a job description or job title that is very accurate with what those duties, skill, and effort, responsibility is, well, that's great, because you can use that to do the comparison. But it's got to really work with what actually the job is. As we know, sometimes you do a job description, it gets stale, or the job isn't quite what it is, so you can modify those, which would help you in your analysis on comparability. Substantially similar is not defined in the Act, but what the guidance indicates is that the jobs are alike to a great or significant extent, but they don't necessarily have to be alike or identical in all respects. I'm not sure if that clarified anything for anybody, but if you study it and think about it, it does help a little bit. Pay differentials are okay in certain circumstances. And what the Act does is it limits to 6 basic instances where you can look to those, if those factors exist, or you have these things in place where you can differentiate on salary, even though it's between different genders. So one is a seniority system. So we pay the people who have been with the company longer. Again, when I'm talking about these systems, they really should be set up. They're pretty defined. You've got some objective standards. You don't want a lot of subjectivity, because then you're going to have people applying them unequally, and then before you know it, you could have a violation of the statute. So seniority system, merit system. You're indicating people are going to get paid more based on how they perform. And again, that means your evaluation systems are going to be important, and how you evaluate people. What are the criteria? You can use those and then start bumping people up. That's fine. But you got to make sure that those have some objectivity and concreteness to them in order to make them work. Next is a system measuring quantity or quality. So we're talking about employees who get paid on a commission basis. I've got a great number of sales, or I'm doing piecework, and I do a lot more pieces than the other person. Okay, you can differentiate and pay me more. Education and training, again, and geographic location. Those also can be, in experience, can all be differentiators, but they have to relate to the job. Just because Robert comes in, he's got an MBA, if it doesn't really matter for the job, it's not going to matter. It's not going to be a way to differentiate. If you had an accountant come in to be a bookkeeper, you could use that because I know accounting, I'm going to be great at the bookkeeping, I know the systems, versus somebody who's never been a bookkeeper before or has done it maybe for a smaller company. That could possibly constitute a way to differentiate. And then travel. Travel can be a differentiator. Again, it's got to be part of the job, part of the necessary requirements of the job in order to apply. One thought I want to put out there is at the bottom, there is also a Federal Equal Pay Act. Our statute that is going to be effective July 1 is significantly different. And under the federal law, it allows any factor other than sex to be a differentiator. That's not going to apply in Massachusetts. And the comparable work under Massachusetts law is much broader than the equal work standard under the federal. So you might be in compliance with federal law, but not be in compliance with Massachusetts law. I would hedge to guess if you're in compliance with Mass law, you will be in compliance with federal law. Pay differentials also, they are not permissible between men and women for any other reason other than those 6 that I listed. It's an exclusive list. You can't come up with other ones and say, well, I'm differentiating on this basis and that should work. You've got to stick with the 6. Salary history is not a defense. You can't bring somebody in and say, well, they were earning this amount when they came, so I started them at the low end. That doesn't work. And there is no intent required to find a violation. You do not have to, if somebody's suing you for a violation, they don't have to prove that you intended to discriminate. It's going to be very objective. If you look and there's a differentiation, the jobs are comparable, and there's differentiation in salary, there's a violation. So what do? You should be looking at your employees, looking at what your pay structure is. to see who do I have in jobs that are comparable, what jobs are comparable. You can start with your job descriptions, but you really got to dig in to make sure you know what the actual jobs entail. Then you got to look at what is the pay between different genders, and while this says men and women, there's different genders than men and women now. So you got to look at it from a gender perspective. You got to look to see, is there pay equality? If there isn't, are there any of those 6 factors that allow me to differentiate? And they exist, so I can rely on those. What happens if you violate? So if an employer is found liable, then you have to, you're liable for the unpaid wages. So that's be the difference. If, let's say it was $30,000 a year, it's $30,000. In addition to liquidated damages of the same amount, so now you're at $60,000, plus the reasonable attorney's fees that was expended by the employee to get you to recognize the differentiation and then come up with the money. You do not have to file with the MCAD or the Attorney General. Some of you may be aware of some of the discrimination laws, which under Chapter 151B had to file with the MCAD. Here you don't. You can file directly in court. You cannot use an agreement with the employee to work for less as a defense. That's not going to fly. And you can't, as I mentioned before, use previous compensation history as a defense. There's a 3-year statute of limitations, which means an employee can go back 3 years. So if you didn't pay me $30,000 a year, equivalent to somebody else, now we're talking $90,000 plus $90,000 plus attorney's fees. So it can get very expensive. It's certainly worth looking into this. There's a violation each time wages are paid. There's a violation each time a decision is made. If you hire somebody and you pay them unequal pay, there's a violation. When you give that person a paycheck, there's another violation. If you adopt a practice on here's how we're going to evaluate and your evaluations are differentiating based on gender, there's another violation. What else is unlawful under the Act which could make you liable for those, the violation of the statute, which would include the attorney's fees? Well, one is you cannot prohibit employees from discussing their wages, their own or those of others, with one, I'm going to say one exception, but with an exception. The exception is if you are an employee where you're in a position where your job responsibilities give you access to other employees' compensation information, well, then you can restrict that employee from sharing that. HR is the easy, typical example. Supervisor is an easy, typical example. But if, other than that, any employee can go discuss their salary with any other employee. Employees can talk about, I understand this person has their salary, you can't prohibit that. In addition, those exceptions, the HR folks and the supervisors, they can talk about their salary. They can't talk about other employees' salary, because they can talk about theirs. So you should take a look at your company handbooks to make sure there's nothing in there that restricts employees from discussing those. Nothing on your forms, nothing on your offer letters, nothing in your contracts that do that. The other big thing, which a lot of people seem to be very concerned about, is you can't seek the compensation history from a prospective employee. You cannot ask them, what were you earning, or what are you earning at your current place of employment? You can ask, what are your salary expectations? But I'm going to give you a big caveat there is you're getting close to the line. And if it's determined that that question was intended to elicit the employee's compensation history, well, then you're going to be in violation. I would submit I don't think you need to ask for employment compensation history. You can set a range of salary when you're putting out your positions, and then you put the person in the spot based on those 6 factors where they fit, or all our VPs are paid the same. And then we differentiate thereafter based on either the work they do or how well they've done it, i.e. their group is off the charts with sales, or some other evaluated factor that's objective and you can back up, a merit system. You can also not require a prospective employer compensation history to meet certain criteria. Again, stay away from compensation history is the simple thing. And you cannot retaliate against an employee who discusses or discloses their salary information or discusses other employees' salary information. And you cannot retaliate against an employee who opposes any violation of the statute or makes a complaint. So what can an employer do with regard to compensation? You can, from a prospective employee as far as prior history, you can confirm prior compensation if the employee voluntarily discloses it. Again, it's got to be voluntary. They blurt it out. You can then go confirm it. Or you can confirm it after you've made an offer with compensation in the offer, and it's been made to the prospect. So you can then check to confirm. So I don't know why you would want to do that, but you can do it. Maybe it's you want to check market and see am I paying market, but there's other ways to do that. Again, I'd recommend staying away from it. I don't see any real benefit to getting close to the line, particularly if you've taken all the key steps to get there and stay behind the line. Why would you want to cross it to have somebody contest when you actually asked for the compensation history relative to when you made the offer? And you can never use salary history, even after you confirm it, to justify any differential in paying employees of different genders different amounts that are obviously doing the comparable work. So the best thing that you can do as an employer is get this affirmative defense. The statute specifically allows an affirmative defense to these types of claims. In order to get it, what you need to undertake and complete is a self-evaluation of your pay practices. And it has to be done within the previous 3 years of a claim and before the claim is brought in court. So do it now. Start it now before the act is effective, and it'll cover you should any claims be brought going forward. You have to demonstrate that you not only completed and undertook that self-evaluation, you have to demonstrate that after the evaluation, if you determined there are certain discrepancies, you're making reasonable progress towards eliminating them. That reasonable progress is going to depend on the size of your business. If I'm a 6-person employed, I employ 6 people, it's not going to take long to do the evaluation and determine these people aren't paid. I do the raise. You can't drop somebody's salary to make it equal. You can only increase the people who are paid less. So for those of you who are thinking, hey, this is great, I saved myself some money, it's got to go the other way. You can easily make that quick switch. Whereas if I've got thousands of employees, it may be tougher to do the evaluation and then to implement it over time. And that is going to be taken into consideration to determine whether you've made reasonable progress so that you qualify for the affirmative defense. And then last but not least, the evaluation has to be done in good faith. So you're taking the appropriate steps and you're really looking into the factors to determine it. And then it has to be an evaluation that's reasonable in detail and scope, again, in light of the size of the employer. You can get a partial defense if you cannot demonstrate that your evaluation was reasonable in detail and scope, and you will not be you will not be liable for liquidated damages, again, so long as you're taking steps towards fixing what you found. The evidence of your self-evaluation cannot be used against you under certain circumstances. One, you have to go through those steps. And it's certain time limitations. So if you do the self-evaluation, nobody's going to come and say, look, here's the self-evaluation. These 6 people were found you've discriminated against them. They're not being paid equally, and one of them's my client. They're not going to be able to use that if the self-evaluation was completed, the violation occurred before the self-evaluation was completed, and you have completed the self-evaluation. Or the violation occurs within 6 months after you have completed the self-evaluation. Again, they can't use it against you. Or, and this is the best one, but it's the violation occurs within 2 years after the self-evaluation is completed, if you can show that you have developed and begun implementing in good faith a plan to address the discrepancies that were found. So that's going to give you the biggest protection. Do the audit. Start the plan and start putting it in place to make progress against the discrepancies, and you're going to have 2 years of protection. So from an employer standpoint, that's the best thing to do. If you're representing employees, I would say forget everything I just told you. Don't do any of this. Anybody have a particular quick question?
Larry, is there, in the terms of equal pay, is there any guidance on, is that within a certain percentage of one person versus the other, a certain dollar amount? Does it have to be to the red cent, equal pay?
Equal pay. Equal pay, and you consider everything. You don't just say, oh, the salaries are equal, but he's getting, stock grants every year worth, 0.1% the value of the company, and she's getting none, or she's getting 0.5, or vice versa. So it's you can't differentiate. So that's a differentiation. Now, if you can fit in one of the 6 factors, then it can be different, but it's got to be based on that. Yes?
In the case of a highly compensated salesperson, what would the discussion be around their compensation? Would there be any differences?
Well, is the salesperson based pay on commission?
Base salary plus commission in most cases.
Okay, so I would say, just top of the head without getting into the details, the base pay would be equivalent for both salespeople. But if you've got a high-performing salesperson who's hitting it out of the park and their commissions are, 100 grand a year, and the other person is getting less, you could account for that and say, okay, now I'm going to differentiate. I'm going to pay you, arguably, a higher base pay, or maybe give you a higher commission, or tweak it a little bit to further incentivize you because you're doing such a great job. I can give you a bonus of more money.
When you're hiring, the pre-hire, what could your discussions be around that?
It would have to be one of those 6 factors. So experience, education, but it has to relate to the job, travel, those types of things. It's really those 6 factors are what's going to do it, or skill, experience, if it relates to the job. Let's say you've got a salesperson selling medical devices, and this person has a engineering degree or had dealt with and understands how they work and can maybe pitch it better. That might be a differentiator. But that's something you really got to analyze.
Mm-hmm.
Yep.
If we use a recruiter and a recruiter violates the act, are we liable or is the recruiter liable?
So when you say recruiter violates the act, the recruiter is not an employer. So the recruiter can ask the recruitee, the person who you're trying to place the job, right, place the job for, you can ask them what their salary is, but you cannot and should not share it with the employer. So if an employer who is looking at your candidate says, hey, what's this person's salary? You can say, I can't tell you. It's not yours to give up. It's not yours to volunteer. If the employee wants to volunteer it, they can. But I would say from a recruitment standpoint, I would advise you.
And if we come up with an offer, the recruiter could say, oh, you should probably go higher or something.
I'm sorry?
If we come up with an offer and the recruiter knows what the pay was, because he can ask, he could advise us when we need to go higher.
Well, there I'd get, so I understood you a little bit differently. So if you're saying that the recruiter is working for you, finding somebody for you,
Yes.
I would treat that person as an agent, and I would not have that recruiter ask.
Okay.
If you are more of a placement agency and I'm out there saying,
No.
I have people and, oh, I understand you're looking for somebody, let me give you somebody, that's how I was answering the first part.
This is someone finding someone for
Yeah,
us.
no.
But what if that person asks, but we didn't tell them to ask, That's what I'm...
Well, I think what I would do is when you talk to recruiters, you sit down and say, okay, we all understand here, nobody asks about salary, because they are your agent, they're working for you. If it's the other one where you're placing, I'm trying to place and I'm going to all these employers saying, I've got people who can work for you, that's a little different.
Hi, can you, very quickly, high level, tell me how we should document this process to show evidence that we're, doing what
The process of the self-evaluation, well, you're gonna set up a self-evaluation plan, and you're gonna say, here's what we're gonna do. We're gonna determine what all our positions are. We're gonna gather our job descriptions. We're gonna look to see how they relate to the actual job. We're gonna sit down with our supervisors and say, okay, what do these people do? What are they actually doing? Figure that out. You're gonna then say, here's the people who are in comparable jobs. So then I match them up. Here's my sales folks. These are definitely comparable. And then I say, here they are. Here's their genders. Are they paid equally? If not, what are the variations? Are they based, do they fit with any one of those 6 factors? Then you find out, okay, I got some problems. I got some discrepancies. These are the ones. I'm going to fix them. And what's my plan to fix them? And is it reasonable given my size and what the fix is? It's $3,000 difference. I would say you can fix that pretty quick unless money's really tight. But depending on the situation, if you've got 500 jobs you got to fix, that may take you a little bit more time. But I mean, happy to talk to you more. But it's a big process. If you look at the guidance, there's attached to the back of the guidance, they give you a broad description of what a self-evaluation plan might look like. Because you can do your own, or you can hire out and have somebody do it too.